Bonsoir, good evening. Je m'appelle Marvin Rotran, je suis le directeur national de la Ligue des droits de la personne de Brith Canada. I'm Marvin Rotran, the national director of the League for Human Rights for Brith Canada. I'm going to start explaining the call in French, and I'm going to come back in English. Speakers and those in attendance can speak in the language they're most comfortable with. After the speeches, we're going to have a question and answer period. Brith est la plus vieille organisation des droits humains au Canada. Nous avons fourni des services à la communauté juive depuis 1875. Cet appel est par invitation, ce n'est pas un appel public. Celle qui veut voir, qui n'était pas invité, peut regarder le lien YouTube. Mais il ne peut pas assister dans la période des questions et réponses des gens sur l'appel. Cet appel est informationnel. On rassemble des organisations et des individus qui s'opposent à la loi 86, mais l'appel ne lie pas personne à une cour d'action. Tout le monde est ici pour partager l'information. Et effectivement, le but est de faire des introductions entre des groupes qui partagent le même point de vue, mais n'ont jamais parlé auparavant. You know, that's kind of an interesting thing. Many of us have been concerned about Bill 96, and there are people on this call who represent 4 different streams of lawsuits against Bill 96, and a couple of groups that have gone off on a different route, that of diplomacy with the government of Quebec. None of these groups, as far as I know, has ever talked to each other. And we thought it important to bring everybody together on the call. First of all, I'd like to give a thank you to the Knights of Pythias, the Bonaventure Lodge of B'nai Brith, the United Community of Russian-speaking Jews, and others who I'll announce during the evening, our partner organizations who helped get the word out for this important call this evening. So tonight we'll hear about several lawsuits asking the courts to set aside Bill 96. We'll hear from a coalition of 23 municipalities who indicate that the law threatens their official bilingual status. We'll hear from Côte Saint-Luc Mayor Mitch Brownstein, who speaks on behalf of the coalition and who will address us on their behalf. We'll also hear about Joe Ortona, the chair of the English Montreal School Board, who will explain how the constitutional guarantees of the English language minority in Quebec to control its own educational system is affected by the bill. He'll also update us on Bill 40. Other speakers will include Andrew Cadell of the Task Force of Linguistic Policy, le Conseil spécial sur la politique linguistique, Don Warnholtz, the president of the Townshippers Association, which has chosen diplomacy over legal challenges, as has B'nai Brith to date. And he will also be on the same wavelength as my colleague Hank Topaz from B'nai Brith, the Quebec regional manager, who will talk about what we have done and some of the problems brought to our attention. We'll hear from well-known constitutional lawyer Julius Gray, who is contesting the bill on several fronts. The power of search and seizure. Julius has noted that the Office québécois de la langue française has the power that police do not in terms of search and seizure. He has raised certain important issues of access to justice, particularly the onerous burden caused by the requirement that all documents in the court be translated despite the constitutional guarantees to a hearing in English. J'aimerais maintenant lire les noms des élus qui sont présents or will be present. Les personnes confirmées est Elizabeth Prass, membre de l'Assemblée nationale de Darcy McGee, Desiree McGraw de Notre-Dame-de-Grâce, membre de l'Assemblée nationale, Michel Setlaki, la MAN de Montréal, a dû donner ses regrets au dernier moment. Elle doit être représentée par Israël Labiod. Brigitte Garceau, MAN de Robert Baldwin, doit être avec nous ce soir. Et Madame Jennifer Ferguson représente Monsieur Gregory Kelly de Jacques Cartier. My excuse there, Jennifer, I'm so used to talking about Greg Kelly that Jeff Kelly that I accidentally confused the two. I want to note the presence of mayors who are either already on the call or will join us shortly. Mitch Brownstein, the mayor of Côte Saint-Luc, Marc Doré, le maire de Dorval, Georges Borrell, le maire de Beaconsfield, Tim Thomas, le maire de Pointe-Claire, Alex Patucci, le maire de Dollard-des-Ormeaux, David Thibault, maire de New Carlisle, Dale Roberts Keats, maire de Bonne-Espérance, Gérald Baudouin, le maire de canton de Havelock, a dû donner ses regrets il y a quelques minutes avant l'appel, Andrew Etheridge, le maire de Blanc-Sablon, Michelle Gibson, le maire de Kirkland. We're expecting councillors Sonny Morose and Stephanie Valenzuela de la Ville de Montréal, Morris Vesley and Tanya Toledano de Dollard-des-Ormeaux. And for the English Montreal School Board, accompanying Mr. Ortona will be Commissioners Ellie Israel, Sophie DeVito, Joseph Lala, and Maria Corsi. I also note joining us on this call will be Maitre Michael Bergman, who represents some of the plaintiffs in some of the cases, and you may direct questions to him as well. Mark Roisberg, who is the community of Russian-speaking Jews, and Minda Mazzoni, Ramon Vicente from Filipino community, Norman Simon from Canadians for Coexistence, and Dario Bocco from the Knights of Rizal. I want to say the following. The call came about because today is the one-year anniversary of our August 1st, 2022 call that led to several of the lawsuits against Bill 96. It created a synergy that led B'nai Brith to hold a press conference and demand minor amendments to the law. The law has caused inconvenience for the Jewish community. It is much more difficult to hire rabbis and religious teachers from out of the province, whereas Bill 101 permitted a 3-year exemption that was renewable and renewable. New candidates only get 1 2-year exemption, and Hank will let you know about some of the institutions that had some difficulties hiring. And I have to say the following. Our effort to engage with the government of Quebec has not led to a great deal of change. And some people in the Jewish community are saying no one is listening, and perhaps we need another approach. In the last days, you may have heard or read about a person who was hung up on by a clerk at RAMQ trying to get services in English. There are a lot of media about a property transfer in the Laurentians with the same family where they offered a death certificate for the member of the family who left the property to them. The certificate was in English, but it was issued by the government of Quebec, and the government of Quebec refused to accept it and said it needed to be translated. Today, the town of Saint Armand indicates that it's having trouble providing services in English to 27% of their population. They've decided to take an expansive view of the law. They anticipate there might be problems. The government said there would be no change for Anglophones in Quebec, yet we're seeing a lot of unease and we're seeing a lot of opposition. I'll conclude by saying there was a poll recently. Angus Reid indicates that 64% of the people in Montreal oppose Bill 96, whereas in Quebec City, where English is far less spoken, 72% support the bill. In our point of view, Bill 96 does not enhance usage of French, but it simply complicates daily life for the English-speaking community. I'll now go to Hank Topaz, B'nai Brith, Quebec Regional Manager. Hank, the floor is yours.
Thank you, Marvin. Honorable members of the clergy, honorables membres de l'Assemblée nationale, honorables maires des municipalités, honorables membres des conseils municipaux, honorables commissionnaires et mes chers collègues chez B'nai Brith. J'aimerais souhaiter la bienvenue à tous nos participants avec nous en ligne ce soir et surtout son éminence, Maître Julius Gray. I feel very honored to be on a call with you, Julius, and of course with all the other dignitaries and panelists. Je tiens à souligner aussi que moi, un immigrant américain qui a choisi le Canada et a choisi le Québec, je suis confortable dans les deux langues. Néanmoins, à ma grande déception, lors de ma recherche d'emploi il y a 8 ans, après avoir déposé au-delà de 100 applications d'emploi auprès des grandes corporations et des agences paragouvernementales de la province, je n'ai jamais reçu d'appel. Même si des autres minorités commencent d'avoir un degré d'acceptation dans le monde du travail du corporate Québec, j'ai l'impression que ce n'est pas nécessairement le même cas face à la communauté juive. Bill 96 has certainly unleveled the playing field for any entity in business, academics, or research from small to large. This not only affects the non-Francophone sectors of Quebec society, but will also eventually penetrate the Francophone sectors in ways that may even been contemplated. By this, I mean that when leaders in business, in science and innovation depend on having the best and the brightest, Quebec will no longer be able to call upon those top global professionals to join our ranks if they are now affected by Bill 96. Many years ago, while in a previous corporate position, I served as a member of the Grande Chambre de Commerce de Montréal. And I attended a breakfast at which the then leader of the PQ, Pauline Marois, was the guest speaker. She painted a beautiful portrait of how she hoped to make Montreal and Quebec a center of excellence by attracting the best possible scientists, the best businessmen, the best professors, the best. And during the question and answer period which followed, I observed to her that people at the height of their careers might just have some teenage children. I then politely asked her if she thought that the PQ's formal policy of forcing education upon the children of immigrant families with teenage children might perhaps diminish the attraction of Quebec to such candidates of excellence. She stood up in her place and slammed her fist on the table 3 times, saying, jamais, 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 never, 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 would the PQ consider removing the regulations which would force French upon newcomers regardless of the gifts those potential immigrants might bring to us. Well, in my humble opinion, Madame Marois and the PQ now appear to have been eclipsed by the CAQ and its Bill 96, and it seems that they may have done so without the messiness of a referendum. What else has the bill done? Marvin asked that I speak to this. The facts on the ground are being felt already. I can only speak for the impact Bill 96 has had on religious institutions in this city, and I am aware of 4 Jewish institutions, including synagogues and schools, which have had to choose from a smaller pool of candidates to fill key positions. Luckily, in each case, an excellent candidate could be attracted. We all understand that the candidates chosen are fortunately the best in their fields. However, in each case, these great candidates were not affected by the schooling restrictions of Bill 96. What does this tell us? Well, for one, in the not too distant past, I can see that the people on this call might remember a little bit of a distant past. Synagogues were blessed with leadership, rabbinical families, which arrived here at a younger point in their careers and family lives. As part of that leadership, they built communities and they built families. The modeling of those communities also took note of the family nature of these young couples and their children. Some of these rabbinical couples went on to share 40 and 50 years with their respective congregations. My friends, this is now an impossibility. The candidates who are now unaffected by Bill 96 are by design later in their careers, and shall we say realistically, they may have just a bit less runway left to give us. That is sad, and it could have been avoided if those in government had determined to promote French as opposed to beating down English. To our community, the message is quite clear, and I would suggest that the message is also quite clear to those of other political parties who realize that the non-Francophone citizen has become mere collateral damage to the aspirations of the party in power. Thank you. Merci.
Thank you, Hank, for your words. I'd like to note the presence of the Honorable Irwin Cotler, Canada's former Justice Minister and our current Special Envoy for preserving Holocaust remembrance and combating anti-Semitism. Welcome, Mr. Cotler. I would like to thank several individuals, Maître Greg Borden and Rabbi Michael Whitman of the Adath Israel. Together, they partnered with B'nai Brith. We wrote to the government of Quebec in 2022. We explained the issues that Hank has just enumerated, and we told them how they could avoid this without in any way taking away from the stated objective of promoting French. We were basically told to wait and let's see how the dust settles. The dust has settled, and we've had absolutely no positive engagement through our diplomacy. I want to note the good work of Mordechai Nelkin, the executive director of the Rabbinical College of Canada, who has provided us with a great deal of information about hiring problems in the Jewish community from outside Canada. The community remains largely Anglophone and has a need to hire in the United States, United Kingdom, Australia, and elsewhere to fill positions in rabbinical colleges, other institutions of the Jewish community, and in synagogues. And suddenly, Quebec has become a lot less attractive for these candidates, many of whom no longer are guaranteed to send their kids to an English Jewish school. We're now going to go to Julius Gray, a household name in Quebec, a respected constitutional lawyer. Julius will explain some of the more egregious aspects of Bill 96. He'll also tell us a little bit about some of the challenges that are already underway, some of which have had an impact, and others that are progressing through the system. Julius.
Thank you, Marvin. When you asked me to list the things, I thought there's just too much. So I'm certain not to go through everything. The whole law is egregious. I think what we can say is that notwithstanding the official goal of protecting French, the purpose of this law is simply to remove English. French is not really in danger anymore. I think Bill 101 had some justification, but this present law doesn't protect French. What it is simply a reduction of English services. It is an attempt to make this society totally unilingual. Now, let's look at some of the more egregious things. First and foremost, the constitutional amendment. Constitutional amendment, which threatens to take away the possibility of long-term judicial review. And you notice that they've gone along demanding that the federal government change its language law to make Quebec and only French. The federal government has said yes. I can't understand that, but there it is. I think electoral politics is what it is today. The constitutional amendment effectively, in the long run, I think, dooms Canada unless it's overturned. The challenges, certainly several of the challenges, question that constitutional amendment. I think it is not a matter of the constitution of the province. It changes the powers and the relations of Canadians across the country, and it should be struck down. I hope it does get struck down, because without it, we're completely precarious. The next issue, very serious, is the notwithstanding clause. Now, remember, the Quebec, it's not the only place Quebec has done it. It's also done it in laïcité, on its secularism law. What Quebec has basically done is it said, whenever its nationalist program is affected, human rights are not important. You can't use the charter. But the thing is, the charter is there precisely for things which are controversial. You don't have a charter for niceness. If you want to say motherhood and apple pie, you don't need a charter to protect you. You would have been able to say that in Berlin 36 or in Moscow 36. You need a charter precisely when something is controversial. Quebec has served us notice. No charter. We will not be held back by issues of human rights. Now, once again, we go back to the basic principle. The human rights, the protection of fundamental rights is central to a democracy. Whenever it takes second place, it means that the democracy is at risk. And generalized use of the notwithstanding clause in order to get through policies, controversial policies, without a possibility of judicial review is a threat to all of us and a threat to all of Canada. And I note that once Quebec starts using it, I'm certain it's a catching phenomenon. Other provincial premiers will decide, I don't have to put up with this. Let's use the notwithstanding clause. We're reducing the charter to a pious wish, and people will finally say it's of no importance whatsoever. So that is egregious and frightening, and it is being challenged by several people, but it's very difficult to challenge because recent jurisprudence, including one in 2020 by Madam Justice Karakatsanis, has said the province can use it in any way it wants. And you see that the propaganda coming from the CAC is that if we're to take away the notwithstanding clause, we're out of here. That's one of the fundamental protections for Quebec. I think it's one of the most fundamental protections for all Canadians to have the charter. French, English, others, newcomers, natives, everybody. Unfortunately, that particular disposition has been adopted, and Quebec is playing hardball with the notwithstanding clause. Now, the next thing, in an attempt to make Quebec entirely unilingual, they've attempted, of course, to transform it. They're saying they're protecting, trying to save the French nature of Montreal. But in fact, the reality is Montreal has always been a bilingual city since the 1770s. What they're really trying to do is transform a bilingual city into a unilingual one, which is a far less attractive goal when you think about it. The courts and the registry offices, an attempt to prevent English from being used by lawyers and notaries, an attempt to force a French version on every procedure is calculated, of course, to make it impossible to use English. What client is going to pay extra when justice is so expensive anyway? It is an attempt to make the Anglophone second-class citizens before the courts. Now, I can tell you this. In my experience, and I've been before the courts, it's going to be 50 years next year. There are all sorts of things terribly wrong with our system of justice. It's too expensive. It's sometimes bureaucratized. There are some random results that are unfortunate. There are all sorts of things that you could criticize about the system of justice, but the bilingualism has worked perfectly. I've never seen anything that was lost because everybody could speak English or French before the courts. And it's bizarre to see a government which, instead of going into legal aid, instead of making sure that justice is accessible, instead of smoothing procedure, goes for the one thing that worked. The same, of course, applies to notarial things, registered deeds. You now see that they won't take death certificates, etc. It's a very dangerous thing. So let's get to the next thing, the services. They said health services would not be affected. Of course, that's wrong, because the issue is not only whether Anglophones are allowed to speak English in certain circumstances, but they have an absolute rule that no Francophone should ever have to speak English. Their principle is that everybody is entitled to speak only French and have no disadvantage from it. I'm sorry, it doesn't work. It's not so in France. It's not so in Holland. It's not so anywhere. And a premium on unilingualism is a terrible thing. But it's worse than that. It's because they've defined Anglophones in a very particular way. What they said is, since Bill 101, we've been trying to Francicize the immigrants. So the only people who are legitimate Anglophones are the ones who were here before or who used English before. The definitions vary, but in fact, what they're doing is limiting the right to use English to a very small group of people who will have to identify themselves. Now, remember, people, they're saying we're not checking, but of course it can be checked afterwards. Anybody who has any common sense will know that I can get into trouble if they later find out that I lie. The answer is that the rights are being preserved for a small group of people, most of whom have left. In the 60s and 70s, the old traditional Anglos have largely left. It's unfortunate. It's a great loss for Quebec, but that is what happened. And now the so-called rights to English services are being reserved for a small group of people, all of it under with the proviso that a Francophone is entitled not to speak English. So I don't know how it will work, but what it seems to me to be is an end to English services. There is another side to it. It's not just what the law says, but once you create an atmosphere where there's a negative thing, if you speak English, people won't. They'll stumble in French, even if they have difficulty with it. They'll think they won't get the same services. Even in the past, people were often worried that if their lawyer pleaded in English, they'd get worse service. That wasn't true. That wasn't the case ever. But now it's obvious that people will hesitate to use English, even if they are theoretically entitled to it. Contracts, municipalities, and so on. I mean, bilingual municipalities remain. And the one thing that's slightly improved, but not completely, is that you can't take it away from a municipality if it's insistent on passing a resolution to remain bilingual. But at the same time, so far, the municipalities are challenging it. Perhaps Mr. Brownstein will explain the various difficulties they're having, but the operation of any sort of service in English is becoming difficult. Now, healthcare services have also been affected, and you're going to get more and more of this, of people refusing to speak English because they don't have to. I do recall taking my 93, 94-year-old father for a hernia operation in Maisonneuve-Rosemont. And everybody spoke English to him, even though he knew how to speak French. But everybody spoke English to him just to be nice to him. I think that type of situation will end now. You may still be able to do it in the English, so-called English, but bilingual hospitals. But I think, once again, the elimination of English is continuing. The limitation on English CEGEPs is, of course, in the long run, they're preparing an attack on McGill and Concordia because there will be fewer candidates and Francophones will be discouraged from going there. They're pretty overt about saying they're afraid that those universities assimilate Francophones. And therefore, the reduction of McGill, Concordia, bishops, etc., to junior colleges of some sort is going ahead full blast. There is the issue of seizures. It's shocking. Police doesn't have the type of powers they have when investigating a murder. They also have the power to create penalties. Those things are being challenged. They're being, certainly in a number of cases, they're being challenged. So are the courts, of course, and the courts have had a suspension. But it is absolutely unacceptable to have a situation when a body of zealots can create penalties, enforce laws, change the rules. And the certificates of francization are another area where they're given absolute power. Most people are unaware, this is being challenged in a separate case in which I'm involved, that the Office de la langue française has said that you cannot have a lawyer or a counselor in dealing with the Office de la langue française. The director of the company has to do it himself. They don't want to be able to get advice, to be able to check what they're saying. It is one of the most shocking attacks on the principles that you're entitled to get counsel. This particular provision is, I think, it's only a narrow one. It doesn't affect that many people, but it is characteristic of the indifference to basic principles of democratic rule, that you will not allow a person to have counsel, you will not allow a person to come with somebody to deal with a bureaucracy. And once again, the professional bodies will not deal with their members except in French. And I've already talked to lawyers and doctors who have said that when they called, they've said, you can speak to us any way you want, but we'll only answer you in French. It's shocking. It's terrible. You know, people are there for their careers, for their future, and they're being deprived of the best of something they've always had. And I would like anybody to show me how it promotes French to tell a doctor who's up for discipline that we will not answer you in English. I do not see the advantage. So the law has absolutely no points that are positive. It removes a status quo, which was excellent, which made Montreal an international city, which was the great advantage that we had, the two cultures and so on. It basically wants to reduce the English to an insignificant minority, and then to be able to say, yeah, we've guaranteed your rights by cutting down who counts as an Anglophone, where real Anglophones, people who speak English at home, will not be able to get services. The various challenges raise all these points. The school board is raising the points about English education. Many of us are raising the notwithstanding clause, the constitutional amendment, the issue of penalties and criminal law. I think the rule of law is in some way at risk. I have not seen, I think one of the last thing I'm going to say is that this law discriminates against Francophones as well. It discriminates against bilingual Francophones who will not be able to use their skill. It discriminates against those who want to have a broader education, a greater knowledge of North America. It is a terrible law, and what we have to do is continue the challenges. What are our chances in the challenges? I think some of the law is going to get set aside. I'm not sure how much of it. I am confident that the constitutional amendment is illegal. I'm sure that the legal parts the law parts are going to get set aside. I think some other things will as well. And I think we have to keep the flame going until Quebec realizes, maybe with a new government one day, that they've harmed all Quebecers. Francophones, Anglophones, allophones, immigrants, Aboriginal, First Nations, everybody is worse off with a terrible, dreadful, repressive law, which...
Thank you, Julius. To manage the call, I understand you said it was only a partial list. It was grim enough, all right? So... and we can come back to you in the Q&A and you can expand on that. Before I go to Mitch Brownstein, I want to note the presence of Pietro Mercuri and Tony Speranza, commissioners of the EMSB have joined us. Sylvia Martin Laforge, the Director General of the Quebec Community Groups Network, and Anwar Alvi, the President of the Islamic Center of the West Island. Thank you also for having come and joined us this evening. We're now going to go to Mitch Brownstein, who's speaking for a coalition of 23 communities. As I mentioned at the beginning of the call, many of the mayors are with us today. They represent communities large and small and all over the province. Communities in the Outaouais, communities on the North Shore, communities in the Gaspé, communities in the Eastern Townships, and communities right here on the island of Montreal, all feel that their legal status as bilingual communities, their ability to service all their citizens, is compromised by the law. Mitch, the floor is yours.
Thank you. Thanks for having me. It's great. You're doing.
Mitch,
Do you hear me?
Yes, but we're not seeing you. We're seeing some white paper. There you are.
You don't see me. Okay. All right. Now you see me. So, thanks for having me. You are a force to be reckoned with, and we thank you, Marvin, for everything you do. Keep on doing it, and hopefully we'll win some of the court challenges and use some other methods. Because I'm a little more positive than Julius. I look at it a different way, Julius. I look at this as purely political. The only reason why the CAQ is doing what they're doing is they want to get rid of the issue of separation and beat the PQ. The federal parties look at the whole issue of French preservation in Quebec is not a major issue in terms of getting them votes or changing who votes for who of those parties. So it's really very political. So what do we do? What do we do? And we know it's political. Yes, the courts, definitely the courts. But what else can we do? So the first thing that we saw in Côte Saint-Luc was we saw that we had to get the 48 municipalities or 49 that had less than 50% of their populations with mother tongue to pass the resolution to maintain their bilingual status. That was after getting it in the law, at least to be able to do so. So we reached out to each one and everyone passed that resolution, which means all 89 municipalities that have the right to bilingual status still have it. That was key. But what else happened? So the next thing that happened was we saw Bill 96 passed, and in June, certain provisions came into force, including the requirement to prove that you have access to English services. And we heard about that announcement when the message came up. I think they called 611 in Montreal, and they gave them a whole long story that you need to say, prove that you're this or that, or promise that, you have rights to English services. So our director of communications thought, why don't we, we're a bilingual city, we're allowed to provide services in English and French, irrespective if you've been here for 6 months or not, or any of these other things. So we'll do our own little message. And the message was funny. And it hit a nerve. It hit a nerve with the minister. And it hit a nerve with many Quebecers, not only Anglophones. Many Francophones said, this is ridiculous. And I think we need to realize that we have to reach out to the common Quebecer and try to get 1% at a time to realize the negative effects that this has. And it's only dividing Quebecers, making people unfriendly to each other. Punitive policies will never protect the language. The only way to protect language and culture is with positive policies that will encourage people to participate and learn. That's the reality. We see it in an Ulpan in Israel. We see it in other countries. You don't use punitive policies in order to protect the language. So 1% at a time. But then again, we have in bilingual cities, we still have problems with Bill 96. We are affected. There are, the law covers 5 areas that affect us as bilingual cities, meaning that we have to provide our communications, our contracts in French. The obligation to adopt the resolution still is an obligation if you forget to do it. Some clerk forgets and got the notice and forgets to do it, you'll lose your status. So that you got to do that every, I think it's every census. The illegal search and seizure is very problematic because the illegal search and seizure means that anybody can make an anonymous complaint, the OQLF, and somebody could come in there and start seizing our computers and our smartphones and look into, without, beyond what's, as Julia said, beyond what's allowed in a criminal case, and then penalize us. And cities rely on grants from the provincial and federal government, and those grants can be taken away from cities? And then how would we operate? So, and there's also the disciplining of employees. So we're looking at all of those issues. We're counting on Julius, who's representing the 23 municipalities. But we win for all 89. And if we look at it, it's not only the charters that are being infringed, but Bill 96 violates another Quebec law, the Act respecting access to documents held by public bodies and protection of personal law. So personal information. So there are other areas that we're able to challenge in the law. And I do believe, as Julius does, that these areas of law, such as the illegal search and seizure, taking away grants, should be struck down. And they're key to being struck down if we want to ensure that we're able to continue to run our municipalities in the way that we've done. We got some interesting quotes. I'm going to mention you, Dale Roberts. I want to read your quote because I think it's quite a good one. The mayor of Bonne-Espérance. She says, Bill 96 created much confusion with regards to the obligation to use French for all contracts. It's absurd that our municipality, where 99% of the population has English as their preferred language, we can't produce contracts with suppliers in our community in English. And I thank you for that quote, Dale. It just gives you an idea of the absurdity of some of the provisions in the law. The municipalities that are involved in our case officially, although like I said, all 89 will benefit, is Baie-D'Urfé, Beaconsfield, Blanc-Sablon, Bonne-Espérance, Chichester, Côte-Saint-Luc, Dollar-des-Ormeaux, Dorval, Havelstock, Hopetown, Casabouza, Kirkland, Île-aux-Allumettes, Montreal-West, Mulgrave et Derry, New Carlisle, Pointe-Claire, Centreville, Shenboro, Shingawaki, Stanbridge East, Wentworth, and Westmount. So it's a full spectrum of big and small municipalities from across the province. And I do believe it's going to have a major effect. But then again, I will repeat, we need to continue to have our good humor and try to get one person, whether they're Anglophone or Francophone, to realize the detrimental effects of the law, that it only divides people, creates division between people who used to be good friends. We don't want that. It's not good for any of us. And we need to have a little bit of humor and a little bit of positive hope in order to ensure that we can, this will change. I do believe that every type of political situation is cyclical, just like separation was. So this will change too. The question is when and how. It's a cyclical movement right now that says that we want to create a unilingual, as Julia says, Quebec, but it's cyclical, meaning that it's not something that really is good, and people in time will see that. So thank you for the time.
Thank you, Mayor Brownstein, and thank you for having played a big role in getting the mayors to form this coalition. They carry a lot of weight. They speak for a lot of citizens, and I would point out they're not all Anglophones. Many of them are Francophone mayors of communities with an Anglophone minority, or even some where Anglophones are actually the majority of citizens, but they're Francophone mayors. I think you've hit on two things. We've got to reach out to common Quebecers. Why? Because guess what? People actually get along pretty well in Quebec. There really isn't daily tension between communities. People get along with their neighbors. And in fact, when you really talk to your neighbors, people say, you know, we don't understand the problem that's being solved by this law. And as such, I think there is an opening. Before we go to Joe Ortona, I want to mention also on this call, Julian Feldman, Commissioner of the EMSB, had joined us, John Derrick from the Knights of Pythias, Ramon Vicente from the Filipino Family Services. Welcome, Ramon. I'm now going to go to Joe Ortona, who is the chair of the English Montreal School Board and who's been in contact with quite a few commissioners. The board has been in the news a lot. You challenged Bill 21, you challenged Bill 40, and you won. I understand Bill 40 was appealed by the government of Quebec. We're still waiting for that judgment on that appeal to come out, and it's been over 2 years. You challenged Bill 96, and now I understand you actually may challenge Bill 23, which was recently adopted by National Assembly, which is seemingly an end run against your victory that you won on Bill 40. So we'll see where that goes. Mr. Ortona, thank you for making yourself available. I understand you returned from vacation and you're in a different time zone than us, even though you're back here in Montreal. So we really appreciate your being here live. I give the floor to Joe Ortona.
Thank you. Thank you, Marvin. And thank you for inviting me when you told me that we were having this meeting on August 1st, even though I just came back and got home an hour before the call from a trip overseas, and I'm on I can't sleep on an airplane, so I'm on 23 hours without sleeping. But I was hoping that there wouldn't be a delay, and I was hoping that I would be able to be here because of how important this is. And so before I get right into Bill 96, I just will give a quick update on where we are with our other court challenges, because the English Montreal School Board has 3 current court challenges with the government over various pieces of legislation that we find to be unconstitutional. And the first one is Bill 40. That was the bill that abolishes school boards and creates school service centers. And what we were able to do then in 2020, we obtained an injunction that blocked the application of that law for the English language school boards. So the English school boards to this day continue to be school boards. The French side, that system was completely abolished. Now, the government did appeal that injunction that was granted in 2020, and their appeal was denied. So the judgment in Superior Court on the injunction was upheld. So we've been able to be a school board until we get a decision on the merits. That case was heard from April to June of 2021. So we are on 2 years and we still don't have a decision. I have every reason to think that a decision is going to come sometime soon, because any lawyer that I've spoken to has told me 2 years is exceptionally long to be waiting for a decision. So I expect it to be quite lengthy. Obviously, if there's a delay, there must be some reason. But I think it's going to be coming very, very soon. And I wish that I would have had an update for you on Bill 40 here tonight. Unfortunately, I don't. But if keep following in the news, and you'll be seeing that very, very soon. So obviously, Bill 40 was fought on the grounds that, the linguistic minority, which is in the English-speaking community in Quebec, has the right to manage and control its school system, and that school system, is done by electing its representatives through universal suffrage in elections, all of which, system was done away with or created in a very complicated electoral college system under Bill 40. We also challenged Bill 21, the religious symbols ban. We challenged it on 2, the EMSB challenged it on 2 main points. One is Section 23, again, our right, the English-speaking community's right to manage and control its school system, the right to decide, which personnel that we can hire, which teachers we can hire, which teachers that we can promote to school principals without arbitrary criteria that the government set, such as, the wearing of religious symbols. We also challenged it on Section 28 of the Canadian Charter, which is gender equality provisions, for which there's very little jurisprudence, because most of the gender equality challenges are done under Section 15, which is covered by the notwithstanding clause. But Section 28 is not covered by the notwithstanding clause. And I forgot to mention that Section 23 is also not covered by the notwithstanding clause. And so we're hoping that we're going to be able to make a new case law with that. That's currently in the Court of Appeal, and we're waiting for that decision. But what many people don't know is that we were actually successful on our Bill 21 challenge. The EMSB won on the Section 23 grounds. And so if that is upheld on appeal, we would be allowed to hire teachers who wear religious symbols, and we would be allowed to set our criteria for the teachers that we hire. So on to Bill 96 now. We were the first to launch the challenge, I'm proud to say, was the English Montreal School Board. And I think Julius Gray, Mitchell Brownstein gave very good examples and good explanations about how this law infringes on the fundamental rights of the English-speaking minority, and they gave good examples of how, good examples of how the law has a negative impact on our community. The English Montreal School Board is essentially challenging Bill 96 on 3 main points, and that isn't to take anything away from any of the other challenges. I think the more challenges there are, the better. There are obviously some challenges that are touching upon some of their provisions, and some challenges are touching upon the same provisions. We are challenging this bill under Section 23. Again, the English-speaking community's right to manage and control. Why is that important, and how does Bill 96 affect the English-speaking community when it comes to public education? Well, we're expected to practically function in French exclusively, almost exclusively, even though we're an English language school board. We are expected to communicate in French when we are expected to have written communications either in French or in English and in French, which doesn't make any sense. And I think Mr. Gray gave an example earlier before. Who's going to, and in his example, he was talking about money, but we can use the example for time as well. Who's going to take the time to do everything in both English and French if you can do it in half the time and only do it in French? And we're an English language school board, and we shouldn't be obliged to be functioning in French. In our communications internally with our employees, and in our communications with other commissioners or employees of school boards. And even though sometimes politicians have come out and said that, that's not really going to apply, or that they're not going to be very, very rigid with that, I think we've seen some really clear examples in the media recently about how the law can be applied, or how some people come to interpret how the law should be applied. And you see the impact that has. People are being hung up on the phone because the people are refusing to speak to them in English, and that sort of thing. And all it takes is an anonymous complaint to the OQLF, and then the OQLF would be investigating us, and they would be applying the law in whatever way that they interpret it. So we're an English language school board. We have the right to manage and control our system. We have the right to preserve our language and our culture within our board and within our schools. So that's the first main point. The second main point that we're fighting is Section 133 of the Constitution Act of 1867. So that's everything that touches the bilingualism of the courts of Quebec, the language of proceedings, the language of documents to be drafted. We know, of course, that that's already been challenged before. And so the jurisprudence on that is very, very clear. And I have a terrible understanding of why the government thinks that they could force that everything in the judicial system has to be French or has to be translated. And of course, that would have a negative impact on us as well. We have pending court challenges with the government. We, by the looks of it, with Bill 23, we're going to have future court challenges if they continue and go ahead and adopt that bill. We're going to have future court challenges with the government. That's a negative impact. That's an extra added cost onto our system. And the third point that we're fighting is Part 5 of the Constitution Act 1982, and that's everything to do with the amending formula to the Constitution. Quebec, this government has decided under Bill 96 to unilaterally amend the Canadian Constitution, which is something that is unheard of. The Canadian Constitution is very clear. One province cannot amend the Constitution of Canada. There is an amending formula depending on what it is. There's what we call the 750 rule, which is 2/3 of the provinces representing at least 50% of the population. In some cases, to amend the Constitution, it requires the unanimous consent of all of the provinces. But one thing that we know is that one province cannot decide to unilaterally amend the Constitution Act of 1982, even if it is to include provisions that touch upon exclusively on Quebec, to say that Quebec is a nation, that the common language, and that the common language is French. And even though no other party has come out and spoken on that at the or even at the federal level, nobody's been fiercely opposed to that or really open about that issue. That doesn't change the fact that the Constitution is clear, and it also opens the door to allow Quebec to amend any part of the Canadian Constitution that it wants. If Quebec can do that and add that to the Constitution Act of 1982, then what's to stop Quebec from saying we amend the Constitution that the bilingualism of the courts doesn't apply to us? What stops Quebec from saying Section 23 applies to the other provinces and not Quebec? It's a very, we're in uncharted waters with what the government is doing. It's very, very dangerous what is occurring, and so we felt that it was very, very important that that be challenged as well, and that the courts send a clear signal and a clear message that would apply to all of the provincial governments across this country. That can't be done, that's ultra virus of their jurisdiction, of what they would be trying to do. And I would just like to end with this, and if anybody has a little bit of time, the notwithstanding clause can only be used to override sections 2 and 7 to 15 of the Canadian Charter and sections 1 to 38 of the Quebec Charter. And those are very easy to find online, the Quebec Charter and the Canadian Charter. And what I did at a public meeting at the Council of Commissioners, when we had to decide whether we were going to challenge Bill 96 in court or not, one of the things I did was I read all of the sections in those charters that are now suspended under Bill 96. We're talking about judicial rights, the right to a lawyer, the right to an interpreter, the right to understand proceedings, the right to have all of the evidence given to you, the right to call upon your witnesses, the right to present a full defense, you know, all of those rights, freedom of expression, freedom of religion, freedom of conscience. And people were very shocked when they saw all of the different provisions, including the right to life. That's one of the, you know, under Section 7 of the Canadian Charter, life, liberty, and security of the person, that is suspended now under Bill 96. And everybody was shocked to see all of the different rights that this law suspends. And we hear about sometimes, you know, unlawful search and seizure, and we're hearing about some of the things that are happening now in the healthcare sector, but we really didn't hear about all of the provisions that are suspended. And I think that really shows how egregious this law is, and really how far it goes in terms of, you know, the repercussions that there are. It infringes upon the fundamental rights of all Quebecers. We always talk about how it infringes upon the minority language community, but it infringes upon the rights of all Quebecers. And as far as I'm concerned, all it does is, you know, inflame even more division, cause more division and more hostility in between the linguistic communities, when we should be working towards finding for more cordial relationships and a more harmonious way of being able to work together. And I think we can get there. Unfortunately, I don't think we're going to get there with this government, and so that's why we're going to the courts. And so I personally want to thank all of the others who are also launching their own challenges, and I'm confident that they will be successful, and I hope very much that they will be successful. Just like I hope that the MSB will be successful as well, and I'm confident that we will be, because we need to send a message to this government that they can't continue to do this. At some point, they're going to have to get that message across. And so it's going to be a lengthy and expensive process, but ultimately, I'm confident that we're going to be on the right side, not only of the law, but on the right side of history.
Thank you, Joe.
Thank you very much. Thank you for your time.
I certainly hope we will hear the judgment on Bill 40 people have been waiting an awfully long time, and that could begin a cascade of decisions that could change the way we perceive of the situation in Quebec radically and very, very quickly. A lot of people have sort of wondered how the government could possibly think that certain of its gestures would hold up in a court of law. It seems a stretch to many people that the government's argument, particularly on Section 23, have any particular resonance with the courts. I mean, the courts are our checks and balances. And, clearly you said uncharted waters. It was, a gesture on the part of the government of Quebec that should have had immediate pushback when there was a unilateral amendment of the Canadian Constitution. It's fairly clear. And you said you read the clauses that were overridden, that our fundamental rights were taken away by the notwithstanding clause, which someone earlier in this call said some premier, someone somewhere else is suddenly going to wake up with a light bulb in his or her head and say, I can do this too. It won't be on language, it'll be on something else, and change the fundamental nature of Canada, which is a democratic country in which the charter has strengthened individual rights. Suddenly we have governments, basically using the notwithstanding clause in a way that was never envisioned. But here, at least you've had the courage to come forward with certain legal challenges that, should you win, will push the government of Quebec into a corner. And we're going to have a bit of introspection and dialogue about how we can promote the French language and respect minority rights at the same time in Quebec. This certainly isn't doing this. And as two or three of the speakers ahead of you opined, this is an effort to reduce English, suppress English, rather than promote French. And by the way, as Mitch Brownstein said, is not what the common Quebecer really thinks needs to be done. it's the program of the current government. I'm now going to go to Andrew Cadell from the Task Force on Linguistic Policy. I note that Maitre Michael Bergman, who I believe is representing the task force, is with us. And in the Q&A, if Maitre Bergman has a few points he wants to add to Mr. Cadell's speech, I'll certainly recognize them. Mr. Cadell, the floor is yours.
Thank you, Marvin. I'm speaking from my family home in Kamouraska in the Lower St. Lawrence region, where my family roots go back 170 years, and I'm an elected town councillor. I have the privilege of being the president of the Task Force on Linguistic Policy. It's a pleasure to be able to join with other leaders of our community. Special thanks to Marvin Rotran and B'nai Brith for organizing this. And by the way, I have met all the key organizations and people on this call, so maybe I'm one of the few. I'd like to begin with a quote from the great father of Confederation, who was a patriote in the rebellion of 1937, Georges-Étienne Cartier. He said, "Dans un pays comme la nôtre, il faut que tous les points de vue soient respectés et que tous les droits soient protégés. In a country such as ours, all points of view should be respected and all rights must be protected." On May 31st, I accompanied Maitre Michael Bergman to file our brief before the Superior Court. Our brief challenges Bill 96, the changes to the Charter of the French language. We're seeking to protect individuals who've been detrimentally affected by this law. Their lives have been changed in the worst possible way by this legislation. And the next day, June 1st, it became worse. I'm the lead plaintiff in the case. Bill 96 has changed my life in some ways. As a former federal Liberal candidate, I am embarrassed at the failure of the Trudeau government to defend us. As a citizen, there's the inability of marginalized Quebecers to get services in English. My elderly relatives, my visible minority neighbors, and rural poor friends, and this is unacceptable. I bought a car in Rivière-du-Loup a few years ago. The dealer gave contract in English as a courtesy. Under Bill 96, that won't happen. My late father, while born in Canada, was educated mostly in Scotland. He will be able to receive services in English today, although he lived in Quebec for 80 years. And there are many Quebec Anglophones who share his story. Our other plaintiffs are a woman with ulcerative colitis who's been refused services in English, a mother whose autistic child cannot receive support in English, a teacher of children with special needs who's concerned that quotas and funding from the Quebec government will affect his livelihood, an elderly Quebecer who may not be able to provide proof of his so-called historic Anglo status and won't be able to receive treatment in English. A businessman who operates in English, whose company of 21 employees is having trouble expanding its operations in Quebec. The support services in his industry are only available in French, making it difficult to work with the government, given that investors and customers, both locally and internationally, all conduct business in English. Our case deals with the egregious effects of the law on ordinary Quebecers, people who could be your neighbors, relatives, or friends. These are real-life situations with, in some cases, life or death consequences. But in so many ways, all of us here challenging Bill 96 are part of a great family, a great community. We complement each other, and I'm proud to be associated with them. I'd like to explain why we've taken this step. First of all, it relates to our vision and our mission. The task force envisions a linguistically tolerant and inclusive Quebec, where constitutional rights and freedoms regarding political representation, education, health, social, judicial, and other government services are guaranteed in both official languages by law to everyone in the country, regardless of their background. And our mission is that we will represent those individuals, partner with organizations, and help coordinate representative groups to advocate for a bilingual society, taking action to expose and oppose legislative and other measures that ignore, defy, or disrupt linguistic rights and freedoms, as inscribed in the Canadian Constitution or the Quebec Charter, and reduce or hinder the vitality of or services for communities because of linguistic restrictions. Au début, j'aimerais dire que toute ma vie professionnelle, j'appuyais des droits des francophones au Québec et ici. Je suis francophile et je suis très fier de m'exprimer dans ma langue et la langue de mes ancêtres canadiens-français, racines qui datent au Québec depuis 1640. Et je dois dire que la section dans la loi 96 qui donne les mêmes frais de scolarité pour les francophones au Québec que les Québécois est une chose que moi, j'ai demandé et je fais de lobbying depuis 30 ans. The Task Force on Linguistic Policy was founded in the spring of 2021 when the Quebec government tabled Bill 96. At the time, the consensus in Francophone Quebec and the news media was that this represented some minor changes to the charter of the French language, but it was far from a radical reform. However, upon a closer analysis by our experts, we could see that this was a full frontal attack on the Anglophone community of Quebec. Then the federal government tabled Bill C-32, later Bill C-13, the amendments to the Official Languages Act. As you know, it incorporated the Charter of the French language and recognized Quebec as a unilingual French society. Within a few weeks, a group of concerned citizens had formed a committee and swiftly moved to create the task force. We were the first organization to warn of the excesses of both pieces of legislation. Of course, we were ignored at first by the so-called serious people, and then they read the laws as well. They realized we were right. Sadly, our members of the National Assembly were the last to realize what a threat Bill 96 was, and they supported it in committee until the last minute. As for Bill C-13, our MPs were intimidated by the Prime Minister's office into voting in favor, with one exception, Anthony Housefather. It was a shameful moment in Canadian democracy. The Task Force on Linguistic Policy was founded with certain principles in mind. First of all, that Quebec's English-speaking community is a distinct group of over 1 million people who share a common language, as well as established institutions, values, history, and culture. And it's a diverse group of many races, cultures, backgrounds, and experiences. We are a rainbow coalition, larger than most other provinces. It's long been established in a free society such as ours. The security of individuals takes precedence. From the Peace of Westphalia in 1648, the role of the state has been to ensure the security of all citizens. In Canada, our Constitution must take precedence. It is the ultimate law. But today, we are obliged to take the Quebec government to court to ensure our constitutional rights are respected. We're taking the Attorney General of Quebec to court, but also the Attorney General of Canada. This is because both the governments of Quebec and Canada have failed to defend our fundamental rights. We should not have to be doing this. In a perfect world, this law would not have been passed, or these laws and their egregious effects would not have been felt. In a perfect world, provincial and federal legislators would have come to our defense, or the federal government would have intervened on our behalf through a disallowance or an immediate reference to the Supreme Court. This didn't happen, so now we've taken on the challenge ourselves. We're doing it because it's the right thing to do. We'll also be replying to the Federal Court Challenges Program to request the maximum of $150,000 funding of the estimated $500,000 cost. There is no doubt that together as a community, we'll amplify our voice and be the David that slays Goliath. We are hearing more and more stories of the impact of this divisive and mean-spirited law, and more people taking notice. Our cause and our lawsuit to represent individuals affected by Bill 96 depends on public donations. And as we are suing the Attorney General of Quebec and Canada, ironically enough, it will be Canadian and Quebec taxpayers who will be paying to have their rights suppressed. Our efforts to increase awareness in our lawsuit depend on community participation in this form of donations and volunteers. We suggest you go to our website, www.thetaskforce.ca, to see more information. And very soon we'll have an option for you to submit your own story of how you've been impacted by Bill 96, so we can tell the world what's going on here. Nous reconnaissons l'importance de maintenir et encourager le caractère francophone du Québec et du Canada. Il n'a jamais été une question qu'on n'appuie pas l'épanouissement du français ici, mais on peut promouvoir une langue et une collectivité sans éliminer des droits des autres. We recognize and embrace the francophone character of Quebec, but it is possible to promote one language without taking away the rights of another community. In the past weeks, we've seen examples of our worst expectations coming through. Ridiculous messages on government websites, public servants hanging up on English-speaking Quebecers, bus drivers berating children, documents rooted, doctors refusing to speak English. And even here in my own backyard in Kamouraska, guests from Ottawa were told, "On est au Québec, ici on parle français." This is not the Quebec I know and love and chose to move back to after 3 decades abroad and in Ottawa. One might have expected our leaders to come forward and denounce this outrageous behavior, but Premier Legault, who on election night in 2022 declared himself the premier of all Quebecers, has said nothing. This is disgraceful. I will say that in French. Monsieur Legault, votre comportement dans la question linguistique et envers vos concitoyens le Québécois est disgracieuse. To all Quebecers of good faith, I say, do not lose heart. I know many of you feel your future here is in debt, but we have stayed or we've returned because Quebec is our home. We have faced many such obstacles together before, and our community has adapted, survived, and thrived. With the support and encouragement of those of good faith, we will continue to do the same for generations to come. And we will use every means at our disposal, including the courts, the media, and the public forum. We owe it to those who came before us and to those who follow to ensure our rights are never diminished. We will fight with every fiber of our being, and we will never, ever falter because our cause is just. Thank you for your interest.
Thank you. Thank you, Andrew. I'd point out that when you announced your suit, there was quite a lot of publicity about it. And we've had quite a few questions about who your group is, what you're doing. Less well known perhaps in Montreal than elsewhere in the province, but we're glad that we've made contact with you, and we look forward to having you part of the dialogue, because we really believe we need to start talking to each other. As I started this call, we've all been on different tracks, and there's been very little dialogue between the groups. Putting them all together tonight is almost unprecedented. I'm hoping that's just the first little step towards a broader coalition, where even when we don't necessarily agree on strategy, we can at least know what each of us is planning to do well in advance. Thank you very much. Before I go to our next speaker, Don Warnholtz, I want to note the presence of Linda Bell-Serponi, the president of the Montreal Council of Women, Mr. Mark Roisberg, the president of the United Community of Russian-Speaking Jews of Quebec. I note my colleague, Rich Robertson, the director of Advocacy for B'nai Brith. He's located in the Toronto region. And I want to thank, before I forget, because I always forget, Lucas Fuena and Bernie Helrech, our technical support today from B'nai Brith that's making this call so smooth. Like B'nai Brith, another group didn't sue, but pursued the path of advocacy and diplomacy. And that's the Townshippers Association, a group that has a long history in Quebec. We in Montreal sometimes forget there are a lot of Anglophones outside of Quebec. The Eastern Townships was founded largely by English-speaking immigration in the 18th century, has a long history, deep roots of Anglophone families who've been there since the 18th century. Some parts of the Eastern Townships have over 20% Anglo population, such as Brome-Missisquoi, I believe Memphremagog's 15%, Sherbrooke 10 to 12%. So there is a historic Anglophone community. It's fairly large and well rooted in neighborhood. The Townshippers have reflected their needs and advocated for them, all sorts of issues for decades. Don is the president, and he'll tell us about what the Townshippers have done, why they've chosen not to go the route of lawsuit, and where they're getting. And I hope they've been more successful than we have at B'nai Brith. Don, the floor is yours.
Thank you. The Townshippers, we've been around since serving the English-speaking population of the historical Eastern Township since 1979. So we've been there for a while, and quite often language issues are Montreal-centric, and when they look to see what's happening in the regions, quite often we are consulted. Our mission is to promote the interests of our community in the region, to strengthen our cultural identity, and to encourage the full participation of the English-speaking population in the community at large. To achieve this mission, we work to retain and attract English speakers to the region. Granted, this has become much more difficult due to outmigration because of language laws like 96. The effects of this on vulnerable communities, especially the elderly, is a serious problem. We advocate for the needs of our community at various decision-making levels. We try to engage young people and foster new leaders. And importantly, we present the English-speaking community as an active participant in the larger community. Some examples of this are former president, and he's on the call tonight, I believe, and former executive director are both active members of the board of directors of our local CSS3. When I formerly served on the Provincial Access Committee for English Language Services, our region was often regarded by other members of the committee as one of the healthiest in terms of collaboration and services. And I think that's in big part to the engagement of our community. When they were reconstituting the regional access committees, not only were we solicited to help find candidates, but were asked by the PDG of the CISC to serve on the selection committee. The strong collaboration between the local health authorities and the Townshippers during the pandemic and the vaccination programs. We helped with translations, the dissemination of information, and the members of our community were extremely pleased with the services they received in English during this time. Our priority is engaging with the Francophone population, as mentioned a few times this evening, and we think that's critical. We often receive invitations from local French media provide a regional viewpoint on language-related issues. Our messaging often begins with, we do support the protection of the French language, but we're in disagreement with the way it is being implemented, especially when it touches individual rights. We need to reach out to the population, the people, the Francophone people, so they understand on a deeper level what effect these laws have on people. Francophones often have a superficial knowledge of the measures, and they hear the political rhetoric of the need to protect French, that their language is in danger, and this justifies extreme measures. But I think that people here, they generally have a strong sense of justice and a respect of individual rights, and we need to build on that. When we talk to them, we explain a few of the issues, they're amazed. That makes no sense at all. Reaching out was particularly effective, a particularly effective approach in our region during the debate over maintaining bilingual status in the community, in the municipalities. Like, why not make these services available to citizens when it doesn't hurt anyone else or endanger the French language? Concerns were raised, people were worried about the borough of Lennoxville if we were going to be able to maintain our status. Members of the community got involved. Ultimately, the Sherbrooke City Council was unanimous in approving the decision. I have to say it's encouraging, as Mr. Bronstein was saying before, all the municipalities across the province that had to choose to keep their status, they did. And of course, a bilingual status alone is not enough, but at least it opens the door for some services. And it just does show that there is a willingness to help out and to move in those directions. Sometimes people question why our organization is not more involved in organizing protests and public demonstrations. In fact, that's part of the reason I'm here tonight with you. I was interviewed a couple of weeks ago by a local newspaper, and the journalist was really questioning why we aren't more involved in political action. The headline of the story was, "Townshippers won't plan protests against contagious language law," the president says. In the article, I simply explained our approach and point of view, and subsequently I was invited to be here this evening. First of all, we are nonpartisan. We opt for direct diplomacy, and that aligns with our commitment to remain neutral on political alignments. We work with politicians from all parties, emphasizing our shared duty to serve and represent people, regardless of language, race, and background. This reinforces our message of inclusivity and community cooperation. Effective communication is so important. With direct diplomacy, we talk to decision makers. This helps us share our concerns and solutions clearly. When we have an open and honest discussion, politicians can understand our community's issues better and make well-informed decisions. We focus on building relationships with them. This way, we can hopefully find common ground and work together. Over the years, we have been very fortunate to be able to develop these contacts and are often solicited and invited to share our opinions. An example of this in this year's leading up to the implementation of Bill C-13, as we've mentioned before, has been very important in the language issue. We've always looked to the federal government as, well, they've got our back when it comes to language. During the build-up, we actually were invited, and we had 4 separate occasions. We met the Minister of Official Languages until last week, Jeanette Petitpas-Taylor, and 2 other federal ministers from our region who have been very effective in helping us gain access. We highlighted our objections, especially to the inclusion of 96 in the legislation, and shared specific difficulties in our community based on language issues. We always look to evidence-based arguments. In these discussions, we try to present strong arguments backed by facts. This makes our case even more compelling. In terms of our community, employment is a major concern, which has not been helped by the arrival of 96. The unemployment rate for English speakers in Quebec has risen, reaching 10.9%, which is 4% higher than that of French speakers at 6.9%. This gap has doubled since 2016, so it's going in the wrong direction. Our median income is $5,200 less than Francophones. The poverty rate for English speakers is 10%, which is almost twice as high as 5.8 for French speakers. This brings many socio-economic issues into play for our community, especially in the rural areas. Through the direct contact we address this problem with not only fact, but narrative and real-life examples. One of our board members works at finding job placements for English-speaking people coming out of technical schools. With the application of 96, many Francophone employers are reticent to accept English-speaking students as they're not sure, are we allowed to speak to them in English? Questions that come up. Together, statistics and examples are hard for the political representatives to ignore. When we speak to these types of issues, we hope to be able to influence either a modification, a clarification of the law, or to find measures that minimize the effects on our community. Some of the federal funding that was promised to the English-speaking community after C-13 specifically targeted employment. Was this a direct result of our interventions? Hard to say, but it certainly didn't hurt. At the same time, we're not in opposition to other types of efforts to improve the lives of the English-speaking population across the province. We recognize and support the importance of the various core challenges that are underway. One of our board members who's here tonight, Peter Starr, is on the board of QCGN, who advocate and address strategic issues. And some members of our community are engaged in the actions of the task force. But it's our position that the open communication, respectful engagement, building relationships, and having strong arguments, we can work to build change, influence decision, and find lasting solutions. Thank you.
Thank you, Don. Before I open the Q&A, I'm going to ask you a question, because in one of our conversations, you said you had engaged with the local member of the National Assembly who sat with the CAC, and you said there was actually good cooperation. At the National Assembly, the entire CAC caucus voted in favor of the bill. The PLQ voted against. I understand PQ voted against because the bill didn't go far enough in their estimation, but the PLQ did raise certain of the arguments that we're hearing tonight on this call. But in your engagement with the CAC representative, are there any promises to raise any of these issues in caucus with the premier? Have you seen any movement? Because we've tried to do the same thing, and I have to admit, received a very warm video from Christopher Skeet, the minister, dealing with Jewish Heritage Month and some statements against anti-Semitism, but we haven't seen any movement on our main ask for minor amendments that would make it easier for the Jewish community to fill vacancies among rabbis and religious teachers, among other posts that need to be filled. So I'm just asking, what concretely has your discussion with your local CAC representatives yielded?
The CAC representative that we have.
Ladies and gentlemen, thank you very much.
Could Sharon please mute her Zoom?
Yeah, it's okay. Sorry for that.
Yeah, no, the CAC representative here, since there is a significant number of English-speaking people in the riding, she has to pay attention to us to a certain level. And she has worked hard. She helped us specifically with an old folks home, finding grants and working for the betterment of the community as well. To say that one individual who's not a minister has a great deal of influence, she has said, well, I have brought it up and I have talked about it. But again, we try and engage, and actually one of our board members is here on the call tonight, and he actually is spending time working in the riding office, helping them. And we've been busy on the federal side lately, and we haven't talked to her as much. And she's reached out to us, hey, I need to talk to you guys again. So one person doesn't have the complete power, but at least the message can maybe get through.
Yeah, I would tend to agree. Anything is positive, and we need one ally at a time. And by building bridges, you can often make major changes. So I welcome that approach as well. Pour la période des questions et réponses, on a dû commencer à 20 heures, c'est-à-dire 8 heures. Pour une demi-heure, on était 26 minutes en retard. L'appel doit terminer à 8h30. Quelques de nos invités à des autres obligations. We're 27 minutes late. What I'm going to do is I'm going to unilaterally extend this call till 8:45 to accommodate question period. You can just simply raise your hands, and when I recognize you, make a statement or ask a question. It can be to one of our guests, or it can be in general, and we'll find somebody on the call that will answer it. If any of our guests have to leave, well, they have to leave, but we're going to close the call, let's say at 8:45. That should give us some time. So the first hand I saw was Mina La Regina. Madame La Regina.
Oh my God. Hi, Marvin. Hello, everybody. Thank you so much for your wonderful words. It's so interesting to see how everybody works. My concern, can you hear me?
Yes.
Okay, so my concern is that I want to know, aside from having a committee to communicate with Francophones, what other hard measures are being taken to let them know that their rights are being put in the dust along with our rights, because we have been otherized since 1976, at least going forward. So it's easy to dismiss us, but how do they dismiss their own? How are we delivering the message to them? And how can we get that message to translate into votes, to vote for people who actually believe in individual rights rather than not? Thank you.
I think that's a very good question. At the beginning of this meeting, I said this call is informational to get the ball rolling. And I'm going to make two suggestions. As I said, we can't oblige anybody to follow up on them. We just felt it was important to get in our own community, English-speaking Quebecers, to talk to each other, because we've been all going in different directions with no contact. And there have been at least 4 lawsuits and different approaches by organizations as diverse as Townshippers and B'nai B'rith. What I'm going to suggest are 2 things. Just to start up, we need a table that meets on a regular basis to share information and to share where we've had success to strengthen all the different streams. Second of all, we need Francophone spokesmen. There are a couple of Francophones on this call, and yes, admittedly, the groups that are contesting are mostly representing Anglo-Quebecers, so it's natural there's a larger Anglo audience on this call. But however, when I've seen groups in the media, I haven't seen a lot of Francophone spokesmen, yet there are Francophones who are clearly saying this law, affects your community, I don't support it, or it affects me in some sort of way. We haven't reached out enough to them. And I think that's a very, very valid observation, and we need to go from there. Obviously, we're not going to solve that this evening, but I think it's an observation everybody on the call can easily buy into. The second person is Harold Forrester.
Hi, everybody, and I have a question for you. At least one store has, I'm having double sound here. I'm going to have to try close this off if I can. Okay, at least one store chain has started to change their signs to be unilingual. A Home Depot on St. Antoine and NDG. And if that's a trend, I'm very, very concerned of that. It'll show that other stores may want to start doing the same thing. And it's the beginning of a trend. What can anybody do? I don't believe there's any law that requires them to do that. They're just being essentially trying to show how pro-French they are. And it's a dangerous precedent. It makes us feel less comfortable being here in Quebec.
Thank you, Mr. Forrester. I'm going to try to answer your question. If I answer it incorrectly, I invite Maître Gray to correct me. As far as I understand, the language of commercial signs is still regulated by Bill 178 that was adopted years and years ago, and it does not prohibit English language advertising as long as French is more prominent. I can't recall whether it was a 2-to-1 ratio in the size of the sign, whatever. First of all, a signage for public health, public safety has equality, and signs in English are perfectly acceptable on the commercial side as well. This may not be a legal issue. You're saying there's a big chill? Well, the answer lies with the consumers. We do live in the age of online purchasing. If you're not happy, you can tell them you're not going to do business there, and you have other options available to you. I think if people are being panicked into making decisions that don't serve a part of their clientele, they just need to hear it from the clientele, and they need to rethink it. I'm going to go to Peter Starr for the next question. Mr. Starr? Mr. Starr, we're not hearing you. I'm going to come back to Peter Starr. I'm going to go to Maître Michael Bergman. Maître Bergman?
Hello. Thank you, Marvin.
Okay, Mr.
I have
Starr,
a comment.
Hold on a moment, please. We're going to Maître Bergman, and we're going to come back to Mr. Starr afterwards, all right? Maître Bergman?
I have a comment in the nature of an observation. Everything that everyone here has said is true, is serious, and needs immediate attention. But there's another element to Bill 96, indeed to Bill 21 on laïcité and the education reform, Bill 40. These laws, principally Bill 96, radically, and in a revolutionary way, changed the entire nature of human rights in Quebec. Because Bill 96 recognizes and gives to the majority collective rights, Collective rights are a concept that is unknown in the Anglo-American English-Canadian legal tradition. The right of the majority as a collective unit to defend and protect itself and to enact legislation which encroaches on or even renders nugatory, in other words, eliminates minority rights. That is very, very radical and goes beyond simply issues of French language or even the notwithstanding clause. Secondly, Bill 96 and to some extent Bills 21 and 40, they're about more than language. They're about identity. Bill 96 basically says the vehicle for the Quebecois identity is the French language, but the identity is greater than simply a language. It's a set of values. And in my view, and the lawsuit that I am advocating and the lawyer on, of which Andrew Cadell, who spoke very eloquently, is the lead plaintiff, recognizes and disputes the ability of the government and National Assembly to impose an identity on Quebecers. The identity that is sought to be imposed, in my view, is the identity of the descendants of the original colonists of New France. The majority of Francophones in Quebec feel their identity is threatened. That may be wrong, it may be a fantasy, a misunderstanding. That is their belief. Third of all, it is clear that although lobbying is important, political action is important, advocacy in the public sphere is important and must continue. So far, it has completely failed. Majority of Francophones are not interested and believe sincerely that whatever these laws are about, it is in their personal interest, both individually and as a community. The Anglophone and Allophone communities of Quebec, frankly, their silence represents a terrible apathy in the face of what is truly radical. The fact that federal politicians have bought into this and leave this community, our community, with nowhere really to go is most disturbing. What is needed is a concerted attempt to coordinate the litigation by the several litigants. Court cases must continue. Bill 96 will be affected by the Bill 21 litigation, which is largely about the notwithstanding clause. And by the way, people who think the notwithstanding clause is going to be a bowl of cherries to set aside are very mistaken. The few court cases from the Supreme Court tend to support the use of the notwithstanding clause as the government and legislature choose to use it. So we have a battle ahead, but the only forum in which we will be heard is in the courts of law. And slowly, over a number of years, these cases will wangle their way up to the Supreme Court. I am of the view that these cases must each be fought, come hell or high water. But let's understand the outcome. The outcome will likely be a constitutional crisis in Canada. These cases go to the very nature and being of this country. We are, in these cases, fighting for the soul of this country, Canada, and what it will be about in the future. If we lose, that will be a terrible loss, not just the Anglophone community or Canadians, but to the world. Because this country is a very unique corner of this planet. And we're not likely to see another corner like that ever again. We must not fail.
Thank you, Matron Bergman. I'm going to go to, we still have 4 people on the speakers list. And I'd like to fit them all in. I'm going to now go to Peter Starr. Mr. Starr, can you come back? I understand you had some difficulty connecting a moment ago.
Yes, but I don't anymore. Thank you very much, Marvin, for holding this meeting tonight. And also thank you, speakers, for being so informative. I come out of this meeting with a lot more information and very energized. And I think ignorance is bliss. And I think the English, not only the English, but the English and French populations of this province are not getting mobilized, are not thinking about their future, are not thinking about their children's future and their grandchildren's future. On one side of my family, we have a French-Canadian side of the family who says to me, well, what's the matter? What's up with this? On the English side of my family, my wife's son left for Ottawa 2 days ago because after a year trying to get a job in the shipping industry, in which he was very successful, he couldn't get it because he wasn't bilingual. He tried, he did a year's worth of instruction only to pack up and move in the car and get to Ottawa this week. I think that what we should be doing is we should be mobilizing people. And I thought that this was a very good way to mobilize people. We should have these calls on a weekly or fortnightly basis. They should be open to the greater population. And what we should do is we should get to them with the bare facts, and we should allow them to know what's going on and what their choice should be and how they should act. Thank you.
Thank you, Mr. Starr. La prochaine personne, Monsieur Pierre-Luc Rioux-Ranger. Pour les gens sur l'appel, Pierre-Luc, nouveau employé à Brith, ici à Montréal. Pierre-Luc, le plancher est de vote.
Merci beaucoup. Thank you for the presentation, all speakers. It was very informative. My question is more in relation to what Mr. Brownstein was saying about reaching to the common Quebecois, the more, I guess, if you want, normal. What I've seen a lot in my time in B'nai Brith, at B'nai Brith, and also just in general from talking to friends, is this narrative or this normalization of a narrative that sort of brings fear of the English language coming back and sort of imposing its will onto the Quebecois, a bit like in the 1950s, where the French Canadians in Montreal were not as let's say equal in terms of job opportunities, and so many of them nowadays sort of come back to this idea of we want to protect our French because in the 1950s we were oppressed. And so my question is, how do we combat this sort of normalization? How do we say that opposing Bill 96 isn't a question of trying to bring English back on top of French speakers, but it's just a matter of saying, I think we should have equal rights for all citizens, whether they be Anglophones or Francophones. This question was directed to Mr. Brownstein. I don't know if he's still here. If not,
Don't know. Mayor Brownstein had another engagement. We did run a little bit late. I don't think he's on the call, but I'll convey your question to him. But
Marvin, he is on the call.
He is on the call. Mitch, would you respond to Monsieur Rioux-Ranger? I don't know if he's actually on the call. I'm just checking to see if he is.
Mitchell, you're muted.
One moment, please.
You can't hear me, eh?
Yes.
Oh, yeah, there you are. There you are.
Oh, now you do. Okay. So the question is, how do you reach out to the common French Quebecer? I think we need to have a media campaign, first of all, on the French media. That people can, that we could all get onto so that we reach out to them. And we have to form coalitions with different groups, with different organizations, both Anglophone and Francophone, so that we can all work together and realize that this is not helping any protection of the French language. All that it's doing is dividing us as people, as friends, and as neighbors. And I think there's a lot of media campaigns. We should be thinking about hiring a good PR campaign. I could already visualize the commercials on TV and on radio showing families and friends not getting along for no reason, and nothing accomplished by punitive measures that will not in any way bring culture or language protection.
Oh, I sent a message to someone.
Thank you, Mitch, for the response. I was going to say, Pierre-Luc, you're exactly the type of person who should be part of this campaign. So this is to continue to be discussed. And Pierre-Luc, you're welcome to work with the League for Human Rights on this issue to get that message out there. I had a text from Rich Robertson. I'm not sure Rich is still on the call, but I think he said we made the case for further collaboration, not only in the Anglo community, but in the French-speaking community as well. There are 3 people left on my list, and I'm going to ask them all to be brief, and we're going to try to answer their questions. Next person is Linda Shui.
Thanks, Marvin. These Bill 96 and the others, they have to be fought in the court, and that's absolutely true. However, there is another way to approach the rest of Quebec. The thing is that there are a lot of things about Legault that people do not like, or they're not even aware that they don't like him. For example, his hero is Duplessis. That he calls him a great nationalist. In actual fact, he's just a great Catholic. He's not a great nationalist. And the people who have examined and looked at the Duplessis regime, these were francophones, and the result, the conclusion they came to was this was la grande noirceur. And right now, Legault is trying to recreate this. The way he does this is by reducing the importance of education. We don't need that. He thinks it's cute that the kids in high school are working more and more part-time and actually quitting. And he is on the road to creating la grande noirceur 2.0. And we have to really tell people that this is who he is and this is what he's doing. And that would get him to be, because the great success of Quebec has been the quiet revolution, and now he just wants to get rid of the quiet revolution completely. So I know it's not, the legal thing is one thing, but I think if we can get people to realize just how obnoxious and how useless he is, and what he wants to do to bring Quebec back to the 1950s, I think that would go a long way to getting rid of him as a government.
Thank you. Thank you, Linda. As a couple of my friends pointed out, if you don't like the government, you need an alternative. So the question becomes an alternative. Now, we're a nonpartisan group, and so are the townshippers, so the others. We advocate and we lobby. And to date, we haven't had a lawsuit, but so the others are suing and the legal avenue. But I point out,
that's important. Absolutely. That's
but
important.
More broadly, in response to your question, it takes a political alternative that can be done outside the context of this call, but it still requires a.
No, it is an ongoing process. The revival and revitalization of the Liberal Party of Quebec, and the head person in that group is Andre Pratt, who, as I'm sure you know, is the former editor of La Presse, former senator, and he is now working on this. Okay.
Thank you.
Thank you.
Thank you. I heard what you said, but again, we don't endorse any party at B'nai Brith. We are
no, of course not. No.
Many of our members may share your sentiments, but as an organization, we are there to work with every party. We clearly oppose Bill 21. We've come out against Bill 96.
Yeah.
We're going to continue to advocate against them. We try to engage. But however, the answer to your question was, if there's a political a government, you'd require an alternative. You've suggested an alternative. The people on the call will either endorse your idea or they will not. Next speaker is Rabbi Schneur Zalman Rabin. Rabbi Rabin?
Hi, good evening.
Good evening.
Thank you, Marvin and B'nai Brith, for hosting this call. I wanted to propose regarding civil status documents like birth certificates, death certificates, marriage certificates. I don't believe it would harm anyone to have them be bilingual. You could have the French bigger than the English, but it's just a really big inconvenience for people who have hold other citizenships. And I know many such people, they're American, Canadian, Israeli, whatever it is. And when you go to your other country, you need to have papers in their language, and you have to pay for an official translation from French for just something which I would believe should be covered by the Charter of Human Rights. Just have it bilingual, and I don't see who would be offended from that.
Thank you. I think you will find an echo on this call. And I think most people would say that should be the case. I mean, we're now seeing that documents that were legally issued by the government of Quebec in English are not being accepted, and they're demanding translation of their own documents. So I don't think most people feel that's an onerous requirement to have such a civil status document. Thank you for that. And the last person, Ellie Basevich, and I'm sorry.
Yeah, my question is, why is there such an apparent silence in the French media? And what would it take to get that changed? Because we need that. And it's just, what's the next step to change the French media's input on the situation?
Thank you for bringing that up. I think that falls into the proposal I made about 10 minutes ago, that we need Francophone spokesmen, that we aren't leveraging those possible spokesmen who agree with us, who want to work with us. And we should not marginalize this as an Anglo-only cause. Yes, of course, the impact on our community is enormous, but however, it affects all other Quebecers as well. And we really got to go out there and get that message out there. I won't say there hasn't been coverage. There has been, but it's not always sympathetic, and it hasn't always been more than fingernail deep and not analytical enough to explain to the average Quebecer why people feel this is an assault on, in fact, an abuse of civil rights. Julius Gray was quoted as saying abuse of civil rights in an article I read over a year ago, and a lot of people on the French side scratched their heads because they weren't getting the reporting that put that into context. So we take your suggestion and we welcome it. Ladies and gentlemen, this concludes this call. I want to assure everyone that there will be a follow-up. I am going to propose to the groups that were here tonight that we create a table, that we meet more regularly. I don't know if we're going to take up Mr. Starr's proposal that it should be every week or two and open to the general public, but clearly we need some sharing of information on a regular basis, and we need to broaden the spokespeople who are talking on this. We need to bring Francophones into the dialogue. Thank you, everyone. Merci à tous et tous pour être ici ce soir. C'est conclure l'appel. B'nai Brith va continuer ses travaux, pas seulement pour la communauté juive, mais pour représenter tous les groupes qui étaient ici, pour les rassembler et d'assurer qu'on rencontre encore bientôt. Good night, everyone. This call is now officially concluded. Thank you,
Marvin. Merci. Au revoir, tout le monde.
Bonsoir, and thank you again to Luca Fuina.
Good night, everyone.
Bernie.
Thank you, Marvin.
Merci beaucoup.
Chan, I didn't notice you're on the call. Welcome for having been here.
Au revoir.
Thank you very much for this initiative.